is litigation strategy. Robert, do you want to introduce yourself?
Yeah, thanks, Mindy. I'm Robert Taylor. I'm Deputy General Counsel at Ziff Davis.
Okay, so I want to talk with an observation about what we're doing today. Most IP presentations talk a lot about doctrine. This is what patents work. Here's what the Lanham Act says, and that's all useful and good. But it doesn't answer the question that your business teams are asking you, which is probably something like, should we patent this technology or keep it confidential? What happens if a competitor copies our brand? Those are the strategic questions, and they need a different kind of answer than doctrine alone is going to provide. So that's the purpose of today's session. Robert and I have designed this from two perspectives, in-house and outside counsel, because these vantage points are very different, and both of them are needed to kind of get the complete picture. And Robert, I don't know if you want to add anything before we get started.
Yeah, for sure. And just to give folks a little bit more background on myself, Ziff Davis is primarily a digital media company. We've got brands like CNET, RetailMeNot, Mashable, IGN, Popular Science, but we also have a cloud services, software, and hardware side. So we design hardware and software to design and implement Wi-Fi networks. We have VPN software, antivirus software. We have some software as a service solutions for voice over IP and email marketing. So we're in a lot of different places, and there's a lot of different IP that you see come up in that context. But with that background, I would just say that some of the strategic questions that Mindy has described above previously, I suppose, are not really they're not hypothetical. They're things that we really see in real life. And a lot of how you're going to answer these questions and to get there with a good quality answer really depends on how the legal team understands the business and how well the business actually understands IP protection. So you want to really get the business and the legal side aligned, and that's a big part of what we'll be talking about today.
Great. Thanks, Robert. And if anybody has any questions, we're going to try to reserve a little bit of time at the end, but if you have them as we go through, please feel free to put them in the chat, and I'm doing my best to monitor it as we go along. So just before we start, everything we discuss today is for general educational purposes. It's not legal advice. Every IP situation is very fact specific, and the outcomes are going to really vary depending on the particular circumstances involved. And I know Robert's views are his own, and they're not in any way the official position of Ziff Davis. So let's go ahead and get into the presentation. So just to give you an overview of our agenda, um, so we're going to start with the strategic framework, because without that foundation, comparing patents, trade secrets, trademarks, and copyright, it's really just kind of a menu. So we want to really talk about the decision-making lens before we start talking about any individual tools. And then we're going to talk individually about each of the four kinds of IP. And we're going to look at them through one of two lenses. When does it make strategic sense? And what are the litigation implications of that choice? Because those are really inseparable. Your protection decisions today determine what your litigation options are tomorrow. And then we're going to end with some practical tips and a playbook that you can bring back to your organizations and use. So why IP strategy matters. So we're going to have three propositions that I think are worth stating really clearly before we go any further. The first is that the IP decisions that you make early, before the dispute, before a competitor copies your work, before litigation is even on the horizon, are the decisions that determine what tools you will have available if things go wrong. Who has leverage, what remedies are available, whether you can even bring a claim at all. Those outcomes are really all traced back to your very first decisions. And so getting them right at that point is critical, because there's some decisions you can make early that are not reversible. The second really critical point is a misaligned strategy. It doesn't just give you less protection, it actually can work against you. For example, if you're going to file a patent on technology that would have been better held as a trade secret, you may have just handed your competitors a roadmap to your IP, and you've then publicly disclosed things. And also on the flip side, if you build your IP protection on trade secrets and you don't have adequate controls in place, you may not have anything enforceable when you need it. So you really have to make sure that your strategy fits with what your IP is and what you need it to do. And finally, all of this strategy has to be tethered to business objectives. What is the company trying to achieve? Is it market exclusivity, licensing revenue, freedom to operate, brand protection? The answer determines what IP tools make sense. And there's not a right answer that's correct in all circumstances or for every company. Something that might work for a pharmaceutical company, for example, may not work for a software platform. And Robert, from where you sit, where do you most often see the gap between IP strategy and business objectives?
Yeah, so one place that we do see gaps often arising is just a lack of communication and coordination between the business and the legal team. So in the worst case, the legal team, they're not even aware that there's a new product offering, and that, of course, would be very bad. Or the legal team's been made aware, but it's not really clear what the product is or does, which can also make it more challenging to determine how to protect that. Other times, it could be a disconnect between business preferences and just the reality of the legal situation. So, business leadership, for example, might want to default to filing a patent, but they don't really understand is that really the right protection here? I mean, that could depend really on what the product does, how long it's going to be commercially relevant for, who the competitors are going to be, and what the company actually needs from an IP standpoint. So the question really that you should be asking is it's not what can we protect, and that is unfortunately a question that we get a lot, but really what does the business need protection for, and what's the best way to get that protection? They sound similar, but they're actually fairly different, and they can lead to very different outcomes.
Great. That's an excellent point. So I also want to kind of orient us to where this fits in the series because this is a five-part IP litigation series. So if you join us from part one, we covered the IP dispute lifecycle, how disputes start, develop, and ultimately resolve. And today is kind of the next step, focusing on the decisions you make before a dispute arises because those decisions determine what options you will have. And then three through five are kind of downstream, covering litigation funding, tactical litigation execution, and then damages and remedies. So our first substantive section is about building a decision framework before you start evaluating specific IP tools. In practice, the most common mistake that we see is jumping too quickly to a solution, as we've said. We should patent this without kind of thinking about what that means. So these are the four questions that we suggest should sit at the front of any IP strategy conversation. They're very simple, but working through them carefully changes the quality of the answers you end up with. The first is, what actually are you protecting? I mean, it sounds very obvious until you try to really think about it carefully, because technology can mean a finished product that anyone can reverse engineer, or it can mean a manufacturing process that never leaves your building. A brand can be a well-known trademark or a product name that you've been using informally for years. The nature of an asset doesn't just narrow your options, it's the entire starting point. And Kenya, that's a really good point that you just made in the chat. I welcome folks to take a look at that. The second question is, what is the business value of this asset and over what time horizon? So this question directly determines whether the cost and the timeline of patent prosecution makes economic sense. A technology with, maybe a 15-year commercial window, that's a very different calculus than one that's irrelevant in 2 years. We often see software just iterating very quickly, and so we might not need the same kind of protection. So the duration of the value needs to be thought about at the beginning, and often I see clients missing that step. The third question, and this one is also, I think, underappreciated, how likely is someone to take this? And would I know if they did? Being able to detect this is a very important thing. In trade secret cases, for example, misappropriation can be unknown for years. So if you can't find out whether infringement or misappropriation has happened, your rights are really theoretical, and that really changes the value of the protection. And then finally, why do you want protection? I know, dating back to the dot-com boom, right, in the early 2000s, everybody who was talking to VCs was like, oh, we have to file X number of patents in order to get investors in the door. But is that the only reason? Is it to exclude competitors from using what you have? Do you want a licensing revenue stream? Do you want a defensive portfolio? Um, all of those goals, including actually trying to, get investment, those all have a different strategy. And you really need to think why before you go down the road to what kind of protection you might want.
And I'll just jump in and say this ties back a bit to what I said above, but what I like about the four questions that you're seeing here is really how it again reframes the conversation from what the business might think about what can we protect to what does the business actually need. And if you're really thinking through these four questions, you're thinking about it in the right context, and it's likely going to lead to a probably more nuanced answer and ultimately a more useful answer for the business. But it does take a lot more time and effort to work through these kinds of questions.
Absolutely. So, building on these four questions, these are kind of the five factors that we would suggest should drive that decision. The first is the nature of the asset. Which IP tools are even available to you depends on what you're protecting. Software code, you could use copyright or trade secret. Um, a pharmaceutical compound or a mechanical invention may be patent eligible. Obviously, for brands, we talk a lot about trademark. And starting with what asset you have, that's really going to define what you're talking about. Second, as we talked about just now, the duration of the value. Patent prosecution can take 2 to 4 years, and the term is 20 years from the filing date. For a technology with a decades-long commercial life, that makes sense. That's very valuable. For something like a feature of a software that's going to be superseded in, I don't know, 12, 18 months, maybe faster these days, that may be wasted. Third, as we talked about the detectability of infringement, can you identify when your rights are being violated? Um, your enforcement strategy has to account for the realistic likelihood that you may never know when you have a claim. And finally, the cost and timing of protection. It's not just filing fees, there's prosecution costs, maintenance fees, the cost of international protection, and the management burden. And all of that has to be compared in a cost benefit analysis to what the return might be. Um, and then fifth, enforcement objectives. What are you going to do if somebody takes your IP? If you're never going to litigate, building an expensive patent portfolio is really just paper. If you're building leverage for cross-licensing negotiations, that changes the kind of portfolio you need entirely. So matching your IP strategy to your realistic enforcement posture is just critical.
All right, so before we get into individual IP types, which we're going to do later in this presentation, we'll spend just a moment on the types of mistakes that we often see in practice. And these aren't really hypothetical mistakes. They're things that I'll see, that Mindy will see, and they're things that you may see as well. Uh, the first, we've written it here as defaulting to patents without evaluating alternatives, but you can really extrapolate this out to defaulting to any one particular type of IP without evaluating alternatives. I'll give you a few examples because this is something that we see both with lawyers and with non-lawyers. Uh, one thing we saw, this was decades ago at this point, but it was, I thought, a very interesting example. There was an entertainment lawyer who had a background in copyright in the music industry. He had a client who had an idea, an invention essentially to do something and needed some software written for it. So he drafted up a contract for a contractor to write software to implement the idea and had the IP assignment provision of the agreement primarily focused on copyright because he was a copyright attorney who did music for the most part. But since there were some patentable inventions behind what was being implemented in the code, and since the agreement was primarily focused on copyright, that created some challenges later when the company developed an entire patent portfolio around those inventions and ultimately went out to assert it. Uh, so it's unfortunate, but if you've got, for example, someone who only does copyright, they may see everything as a copyright issue instead of a little more holistically. But you see this on the business side as well, and it's especially true with patents. And you might see as engineers, executives, and especially investors and other folks who see just patents as this tangible thing that you can really build value on with a portfolio. There's always a strong desire to push and default towards patents. Uh, but the problem is you may end up with some patents that way, but it may not be something that really serves the business. So you may end up spending a ton of money on prosecution for innovations that were really better suited for trade secret protection or that will basically just be obsolete by the time the patent issues. Uh, and we'll get into later what the alternatives would be for patents on that, but it's it's fairly common to see is just this push for patents, patents, patents. The second mistake we often see is treating IP as a legal exercise rather than a business decision. So you don't necessarily want the legal department making all of your decisions on IP. You want the business to be giving input as well, since the legal department really is there ultimately to serve the business. And if you do have legal making all these decisions, it does tend to be more reactive than proactive. You may get missed application filing deadlines because a product was already launched because the business just wasn't thinking about IP and wasn't making decisions on them and just figured they would let legal know at some point later. Relatedly, you might get asked to register a mark that a competitor already started using by copying you, or having to address protection gaps after competitors have already exploited them. So it's just a very reactive perspective if the business is not really involved from the start and letting legal know and communicating with them about what's going on. The third mistake that we see is failing to revisit strategy and markets, risk as markets evolve. And Kenya's question is even somewhat related to this. But more broadly, if you've got an IP program, maybe it was really well designed for a business model from 10 years ago, based on maybe what the business is doing or even what the law was 10 years ago. But that can change, the business changes, the law changes, and what might have made sense 10 years ago or even 2 years ago might not make sense anymore. And having that regular interaction between legal and business leadership to discuss what do we really want to be doing as a business and legally with IP is really important so your strategy doesn't get stale. And back to you, Mindy.
Yeah, and the consequences of these mistakes, I mean, I see them across my desk all the time. And it's not, it goes beyond IP too. I often see assignment agreements that were written by IP litigators or folks who may not know the employment aspects of that and copyright, which we'll get into later, but is a great thing. You need to make sure that you have the right kind of assignment for copyright, and that, where work for hire comes in. And so even those things that happen at the very beginning, maybe before any code is written, can make a huge difference. Um, and most of these kinds of errors were made years before the dispute or before the IP was even really created. But they really limit what we can do once there's infringement or misappropriation. So that's really the central theme of what we want to talk about today.
All right,
So
so well,
go ahead, Robert.
yeah. So we're going to move into particular IP types now. We'll start with patents. So as Mindy noted, I think previously, we're not here to teach you about patent law. You know it. This is really more about strategy. So we'll think about, for example, when it actually makes sense to seek patent protection, when it makes strategic sense to do so, what advantages it provides in practice, and what the litigation implications can be for choosing a particular path. So I'll be carrying most of the discussion here. I do have a background predominantly in patent litigation, and I'll also be drawing on what I've seen on the in-house perspective. So when do patents make sense? Well, there's really three core scenarios, and we'll unpack the logic behind each as we go through them. So the first is when technology is visible or reverse engineerable. So if a competitor can buy your device, analyze it, reconstruct how it works, you've effectively disclosed it to them already. You just haven't disclosed it on your own terms, and you've done it without any legal protection in return. So in that situation, the public disclosure that patent law requires is actually a very small sacrifice compared to what it might appear like, because that disclosure is going to happen anyway by virtue of selling the product. So the patent gives you something in exchange, a legally enforceable right in return for giving up disclosure, but you were going to give up disclosure anyway. The second scenario is really when the long-term competitive advantage justifies the cost. So patents are really expensive to prosecute. A single application can take, 10 to 30 grand, and that's before you actually factor in international filings, continuation practice, maintenance fees. And that can also take several years, 2 to 4 years to actually get the patent. That is a pretty long window in addition to a lot of money. And so you really need that to be able to pay off. So if you think the technology you're patenting and the product you're going to sell is going to actually generate a competitive advantage for a long period of time, maybe a decade, then it's probably worth getting a patent. But if you're patenting an idea for a product that's just going to be completely obsolete next year, then there's not really there's not much value there. Maybe it's just to build a patent portfolio to say you have one, but from a competitive perspective, it's not going to do a whole lot. And third, for business benefits from exclusivity or licensing. So this scenario is when really your business is actually built on exclusivity or licensing. So some companies genuinely are structured around patent-based exclusivity. They might rely on the ability to prevent competitors from even entering a market, or they build a licensing program where what they do, the revenue is less from selling products and more from generating revenue from their portfolio. Either way, in one of those situations, patents aren't, they're not just useful, they're foundational, they're the whole part of the business. Uh, and that's very different, for example, from a trade secret that you can't really start a licensing program with in the same way or get an exclusionary right that a patent gets. So if your patent model does depend on exclusivity or licensing, uh, then you need patents. All right. So next, talking about some of the advantages of patents. So one of the first here that we see is that the first advantage really that patents provide a IP right that's not really like anything else out there. It's a government issued right to exclude others from making, using, selling, or importing your invention. That right is defined by the patent claims, and that's why claim drafting is one of the most consequential parts of the entire patent process. If you've got a narrow, poorly drafted claim, it may potentially get you a patent fairly quickly, especially if it's very narrow, but it may not have much value on the infringement side if you are trying to enforce it, or it might be very easy to design around. And if that's the case, then there's limited use of having gotten a patent at all. If you have a very well-drafted claim with genuine breadth, but not so broad to be invalid, then you're getting a very effective patent, and you've got a legally enforceable monopoly for the life of the patent. So the quality of the prosecution is probably one of the most well, it's as important as the decision to invest at all, because that's what's going to get you your strong exclusionary rights. So second advantage for patents, it's remedies. For patent infringement, you can get lost profits, reasonable royalty damages, and for willful infringement, you can sometimes get enhanced damages of up to 3 times the base award. There's also the potential for injunctive relief. That's harder to get now than it used to be, but it can still be a credible threat in some circumstances. And the prospect of an injunction can potentially give you a lot more leverage than any dollar value that you're attaching to a claim. The third advantage is really more goes towards the balance sheet and business development value. I mean, patents are valuable assets for partnerships. Maybe you want to try to sell your business or go public. Saying you have a lot of patents can sometimes be viewed meaningfully by investors and the public in general. Uh, yeah, we'll leave it at that. So, okay, let's keep going. So, limitation on patents. So, we talked about advantages of patents. There's also some limitations on patents. The first and foremost, and we've touched on this a little bit before, is public disclosure. You're required to disclose what the invention is. That's the trade-off for exclusivity. But by the same token, you can't keep it secret anymore. Uh, and patent applications publish 18 months after filing. So even if you haven't issued a patent yet, if it's still in the process of being applied for, after 18 months, that application becomes public. And that's permanent. So once it's published, you can't come back from that. So even if you can decide very early on before 18 months that you maybe change your mind and want to keep it secret, you still got some challenges there. But after 18 months publication, even before a patent, you're on that track. You can't go back. You've now made public whatever it is you're trying to patent. Uh, Second limitation is cost and time. So patents take a long time to prosecute to get, and they cost a lot of money. But even once you've got a patent, there's maintenance fees you've got to account for. International filings will also create a lot of additional costs. There's a fair amount of administrative overhead in making sure you're timely paying the administration fees in every different country. Uh, and there's also enforcement. It costs a lot of money to enforce a patent, and we'll get into that later. Uh, but when applying for a patent, you really want to think long term. Like, well, there's not just the filing, the fees of drafting the first draft of the patent. You're going to have to go through potential rejections with the patent office. There's issue fees, there's maintenance fees, and there's enforcement fees later. So it's actually a much deeper well of money and investment you're looking to put into when you file a patent than it may first seem. Uh, Third is validity risk. You may have gotten patents. They may be have passed muster with the patent office, but in litigation, they're going to get challenged with a much closer eye and much deeper pockets, excuse me, than what one examiner could do while also examining a whole bunch of other applications. Uh, you also see a lot of challenges now through inter-parties review at the Patent Trial and Appeal Board, in addition through district court. And what we've seen, at least in the PTAB, the Patent Trial and Appeals Board, is a lot of patents get canceled or narrowed. Another risk that you may see is at the time you got the patent, it might have been easily valid under existing law, but 10 years later, the law can change. I mean, we saw this with 101, and some of the patents that you had back then may not be as easy to enforce anymore since they may be more vulnerable, excuse me, to validity challenges now. So just because you got a patent and just because you've got a good infringement read doesn't necessarily mean you're going to win on that because the patent could be invalidated.
And there's been a lot of changes at the PTAB lately when it comes to IPRs. And so that's something you need to stay on top of too, whether you want to challenge somebody's patent or you have some that may be subject to challenge. We're seeing a lot fewer IPRs granted right now.
Also very important. All right, so patent litigation implications. So patent cases, especially if they're between competitors, are really complex and really expensive, or at least they can get really expensive. You've usually got multiple different expert witness disciplines, technical experts for infringement and validity, damages experts, sometimes industry-specific witnesses as well. In a case litigated through trial in a major venue, it can easily reach seven figures. That cost profile can and should change the math on an assertion. You really need to factor in what's it going to cost to take this through a trial and potentially appeal, in addition to the time involved before you send out that first letter or file the complaint with your assertion. And ultimately what it means is patent litigation, if you're going to go through with it, it's a tool for disputes where the stakes really justify the investment because it can be a very expensive investment and a very risky one. You could risk losing your portfolio as well if it's invalidated during the litigation. Second reality, patent assertion it's not unilateral leverage. You can get counterclaimed. So first though, you should expect that if your patents will be challenged maybe at the PTAB or they'll be challenged just generally in district court for invalidity. If you send a letter out threatening to assert a patent, you could get a declaratory judgment filed against you to have them declared invalid, even if you weren't quite ready to pull the trigger yet on a litigation. And if your competitor is a large company, they probably have their own large portfolio as well, and they may counterclaim you on that. Usually what you'd want to do is take a look in advance and see what patents does the competitor have. Do they have something that reads better on us than we've got that reads on them? Do they have more patents? Are they likely to be more valid? Sometimes that can be hard to figure out, especially if it's a large organization with a lot of different subsidiaries and you're not sure where they are, which legal entity has their IP. Another interesting challenge that you can't really predict, maybe it's a smaller competitor going after. They don't have a lot of patents, but maybe halfway through your litigation, the biggest player in the entire industry buys them up. We've seen that happen as well. And then you get a massive counterclaim by the very, very large industry player that bought up the smaller company that was being sued. It can't really predict that. It's not highly likely, but that's another risk you have to keep in mind. Third reality is parallel PTAB proceedings. They can increase complexity. So PTAB and district court will operate on different timelines, and it is more or less a feature of a lot of district court litigation now that you can also expect there to be a PTAB proceeding filed in parallel. But PTAB has different evidentiary standards, different procedural rules. District courts might stay the litigation before them pending a decision from the PTAB because that might simplify the claims in the district court. Or they might not. Judges come out differently on this sometimes, especially depending on the particular circumstances of the case. But managing both a district court proceeding and a PTAB proceeding at the same time and understanding how they can affect each other and maintaining coherent strategy and coherent arguments across them, it takes a little bit more sophistication and takes a lot of time and effort. And we won't go into it a lot here, but that gets even more complex if you've added international litigation. So for example, maybe you're also filing in Germany in addition to the US, in addition to having a PTAB proceeding in the US. It just can get extremely complex very quickly.
Yeah, and I would just add from a litigation side that Again, the pre-litigation assessment is where the most important work happens. What's the realistic validity? What is the likely PTAB exposure? And as I said, that's changed a lot over the past 6, 8, 12 months. What's your damages theory? Have you had an expert, validate that before you actually file the lawsuit? What do we think the other side is going to counterclaim? And again, what does the business want to achieve? I know a lot of times I have clients come in and say, we want to file a patent litigation case tomorrow. Of course, we're never going to file a patent litigation case tomorrow in reality, because we have to do our due diligence too, right? And make sure that we're filing, something that's going to hold up to Rule 11 and hopefully win the day, whatever that goal is. But it's really important to examine those questions and to have a conversation between the business, between in-house counsel and outside counsel before anything gets filed, and ideally before any complaint is drafted. So let's move on to trade secret strategy. And I think, and we've been seeing a lot more attention paid to trade secrets. It used to be, kind of the stepchild of IP. But they are really incredibly powerful and I think still underutilized. The subject matter is incredibly broad. The protection can last forever. Think Kentucky Fried Chicken. Think Coca-Cola. Think the Google algorithm, actually. And when the underlying misappropriation is especially egregious, the remedies can be incredibly strong, whether it's injunctive relief or damages. We've seen some very large damage awards in trade secret cases in the last few years, and which is a big change actually for trade secret cases. However, to have a trade secret and have an effective trade secret, you have to have internal discipline in your company. There's no certificate, there's no registration number, there's nothing you file with anyone. And so their value is kind of invisible, I guess, until something actually happens. And so my goal is to kind of talk you through that and to think about what you can do to protect them before they walk out the door. So there's the strategically correct choice in three pretty big situations. And so let's talk a little bit about those three. The first one is when the technology is hard to reverse engineer from the finished product. So this is the mirror image of what Robert was just talking about in patents. So if a competitor has to buy your product, analyze it, and then try to figure out the underlying process or formula, and that process takes time, expertise, and resources, every year that secrecy holds off, that's a year of competitive advantage that you didn't have to give up through public disclosure. And again, that's the Coca-Cola formula. It's been protected for well over a century. But it also applies to manufacturing processes, algorithms, formulation methods, and a whole lot of other technical innovations. In fact, there's some debate out here, but of all of the opportunities for IP protection for AI, trade secret might be where it fits best and where it would be most protected, at least the coding and some of the other processes involved. The second situation is when the real value of the product lies in internal know-how rather than an invention. So accumulated expertise that a team builds over years of work, the process refinements, the workarounds, the institutional knowledge of how to do something better than anyone else. And, we've seen some of that in some of the litigation about self-driving cars, the Waymo case, right? That was really what it was about. A lot of it was kind of the negative know-how about what didn't work, and that was a trade secret. So then the third situation that we see, and this is you can't have a trade secret without this. You have to have the internal controls necessary to sustain secrecy. Now, okay, so Coca-Cola and KFC both keep their formulas in vaults. Like Coke, you can go to the World of Coke in Atlanta, Georgia, and see the vault that the formula is allegedly in. KFC ships its 11 herbs and spices in. They're mixed in separate manufacturing facilities, and they're shipped separately and then dumped in at their franchisees. They take a lot of steps that aren't really necessary for most trade secrets. But you do have to take affirmative documented steps. You have to have confidentiality agreements with your employees, with contractors, with business partners. You have to have access controls, and what kind of access control really differs in what industry you're in. I would expect somebody in the biotech field to have much greater protection than I would somebody who maybe has a trade secret in the ag industry. I had a client who was involved in well drilling. And their reasonable trade secrets were passwords and locks and confidentiality agreements. That kind of thing is probably not sufficient today in the high tech world. And we're seeing judges ask a lot more questions about that. So these physical and digital security measures and limiting who within the company can see it. Like, does the receptionist need to have access to your trade secrets? Probably not. So you really have to think about that. You have to have a policy, ideally, that's kind of setting forth so your employees know what they're doing, and you have to enforce it. Um, and the reason that I'm really focusing on this at this point is the first question that I ask my clients when something comes in, it's usually not what the defendant did. It's how have you protected this? Because if you haven't done an adequate job, we don't have a case. It's going to be really difficult for us to go into court and do something. So, and again, I lead our trade secret group. I'm a trade secret nerd. I think trade secrets are, in my opinion, probably superior to any other form of IP protection. They last forever, right? Patents expire in 20 years. As long as you maintain your secrecy, you have a trade secret. So if your competitive advantage is embedded in a process or a formula or know-how, that indefinite protection can accumulate value over time that no patent can match. Again, think Coke. The second advantage that we have here is cost. There's no application process. There's no registration fee. There's no renewal. There's no kind of management overhead. The cost is really your internal security program, confidentiality agreements, access controls, employee training, employee exit interviews, and consistent enforcement of your confidentiality policies. So if you have a company that's generating a large volume of protectable information, that absence of a per asset registration cost, it's a genuine practical advantage. Finally, it's incredibly flexible. It's not confined to any specific categories. It's not a set of claims that you have filed that you can never change unless you file, continuation patents. Formulas, methods, processes, compilations, customer lists, projections, business strategies, software architecture, all of that's potentially protectable. And as your know-how evolves, whether it's positive or negative know-how, that new information comes within the trade secret protection umbrella just by keeping it secret and making sure you're protecting it and taking those reasonable steps. You don't have to amend anything or restart a prosecution process. It adapts in real time. However, there are limitations, right? And the most fundamental limitation is really the protection itself can be fragile. A trade secret stops existing the moment it stops being secret. An inadvertent disclosure in a public filing, a data breach, an employee who sends a sensitive document to a personal email account. Any of these could potentially eliminate the protection completely and permanently. So that means that maintaining trade secret, you have to be vigilant, and it's really only as strong as your weakest security measure. The second limitation is the evidentiary burden as a trade secret owner. You have to show that the information has competitive value and that it was not generally known, and whether it was readily ascertainable comes into play in these kind of cases as well. Some states it's an affirmative defense. Some states the plaintiff might have to show that. So your mileage may vary there, but that is often an element. And the critical thing that we're really seeing litigated extensively these days is that you took reasonable measures to protect the trade secret. It used to be I could walk into court with an ex parte trade secret application for a temporary restraining order and walk out an hour later with a TRO. And I can't do that today. And in part of that's because courts have changed since COVID. But the other part is courts are really looking more carefully at whether or not you took reasonable protective measures. A policy that's just on paper but's never actually implemented is not going to be good enough. If some employees signed NDAs but others didn't, if some files were restricted and others were maybe publicly available, that's going to come up. And finally, This is one that I think people are often surprised. There's no protection against independent development, true independent development. So if a competitor develops the same formula or process or technology entirely on their own without access to your information, they're free to do it. This is fundamentally different from patent law, where even an independent inventor who comes up with the same invention is subject to the exclusionary right. So trade secret law only focuses on misappropriation. That's wrongful acquisition, use, or disclosure. And it's not about parallel innovation. So you need to factor that into your strategic analysis.
And I'll just jump in and say from the business side, there's actually a fourth consideration I'd add. And Mindy mentioned before the invisible nature of trade secret protection. That can actually make it a little more difficult to communicate value of trade secrets internally. Think about a patent, for example. You've got an issued certificate, a number, and a scope of claims. It almost feels like a tangible thing you can show to the business. You don't really have that with a trade secret, so it can make it a little bit harder to get the organizational buy-in for a protection program. And as Mindy mentioned, there's quite a bit involved in a real protection program. And so it just gets even more challenging to get that buy-in when it's a little tough to show what you're getting out of it, at least before any kind of assertion is done.
Absolutely. And if the first time and the only time that you're talking about trade secrets with your employees, their very first day and never again, you're going to have a really hard time protecting that. And the other thing that we didn't have on the slide, but I just want to add, it's international protection. Trade secrets can be a little bit more difficult. Not all countries recognize trade secrets. So if you have things internationally, that's something you need to think about as well. Okay, so some trade secret litigation thoughts and implications. So trade secret, the litigation itself is very different from patent and trademark disputes. And first of all, one of the reasons I love litigating trade secrets, they're soap operas. Yes, it's about the actual intellectual property issue, but the cases that make it to be filed, and especially the cases that make it to trial, they're about betrayal. They're about these human emotions that are underlying everything here. And the central questions that we look at are who had access to the information, when did they have it, what did they do with it, and was that conduct wrongful? So we have a lot of discovery. It's often very contentious, and it's heavily focused on electronic evidence in most cases. Deleted files, metadata, email forwarding, printing, cloud storage access. We spend a lot of time building a forensic timeline of what people did with the information that they weren't supposed to take. So that's often critical. The second dynamic that underlies these cases is that injunctive relief is extraordinarily powerful, not automatic. The courts are going to really carefully scrutinize your application, but in the right case, particularly when a senior employee has departed to a direct competitor, an emergency injunction can be obtained within days, and it can stop the use of that information before competitive harm has occurred, and that's incredibly significant. However, you do have to show a likelihood of success in the merits. So you have to show you have a viable trade secret, that you took reasonable measures, and that there's potential for use, access, disclosure that's going to harm you. And a client who comes to a temporary restraining order hearing without a documented protective program, they're in a difficult position. The other thing that relates to the injunction is that often these cases end at that point. There's 2 months that are incredibly busy. And once a preliminary injunction is obtained or not obtained, that's a stepping off point, which is, earlier than in a lot of other IP cases. So the third dynamic we have here is employee mobility. About 80% of trade secret cases involve employee departures. So that means you need to plan ahead for that. Addressing departing employees, proper exit interviews, return of materials. If they had access to your secret sauce, if like they had the Coke formula, you better make sure you're looking at all their devices and making sure there are no unusual downloads, uploads, forwards. Although we have people who are trying to get around that by taking screenshots with the phone or with whether that's their iPhone or Android phone, or sometimes with a digital phone. Were these people looking at screens they shouldn't have been as they were departing? And then again, make sure you're addressing it at the beginning also when you have incoming employees, because you want these systematic processes in place to make sure that employees know what to do. And then the fourth dynamic that I say here is really the disclosure dilemma. So you need to describe your trade secret with enough specificity that a court can evaluate it. And yes, we get protective orders and we limit who can see them in almost all trade secret cases. But courts, although they will issue protective orders and have attorney's eyes only designations, they also have a duty to make everything public that they can. And so we're getting a lot of pushback from especially federal courts who are concerned in making sure that we're only protecting and putting under seal those things that absolutely need it. So that's something that you're going to see. And the other thing on the damages front, I would just add is you often have to make a decision. Do you want injunctive relief or do you want damages? Because once the injunctive relief is there, that often cuts off the damages. So that's a decision that you need to make early in the case and often preferably before you file.
All right. So we'll next turn to trademarks, and I'll just open the point that I think often gets lost in conversations that are usually dominated by patents and trade secrets. And that's that for some businesses, the trademark is the single most commercially significant IP right that they will hold. The goodwill that gets embedded in a well-known brand can be worth more than the underlying technology that made that company successful in the first place. But despite that, you often still see trademark strategy under-resourced in IP planning and underappreciated. So we'll start by talking about what some of that strategic value is in trademarks, which can get underappreciated. So jump to the next slide here. So the first idea is that the trademark it's a promise. It's brand identity and customer association. But when a customer sees your brand on a product or service, that mark is communicating something. It's saying that this came from a particular source, it carries certain quality expectations, and that is distinct from what a competitor is selling. Protecting that signal and preventing other parties from using marks that would confuse consumers about the source of goods and services is how you preserve the accumulated investment in what that brand represents. And if a competitor trades on your brand, they're not just infringing a legal right, they're free riding on what your company is built to establish with regard to that association in the market. And this is really important for consumer-facing businesses. In industries where purchase decisions are driven by brand recognition and reputation, trademark is usually the primary IP right that directly touches on that customer relationship. And if you're not registering and protecting your brand, you're taking on the risk that basically people will no longer appreciate the quality of your product. It creates the possibility that a competitor or bad actor can create consumer confusion, dilute the brand's distinctiveness, or even establish superior rights in the mark that you may have been using yourself, but you did not have adequate protection. We'll get into that point a little bit more in a future slide here, but it's a very interesting one. And the third idea here for scaling across products and markets, trademarks can scale in a way that other IP rights don't. So a well-established brand can be extended into new product categories, new service lines, new geographic markets. That scalability makes trademark portfolios particularly valuable for companies with growth ambition. But it does have some practical limitations for protection strategy. So you need to be registering and protecting your core marks before the brand becomes so valuable that there's meaningful numbers of potential infringers. If you wait until the brand is at stake to protect it, it becomes significantly more expensive and a lot more uncertain in terms of how successful you'll be in protecting that. So trademark litigation implications. When you do have a trademark dispute, there's a few different dynamics that can shape how they play out. It is helpful to understand them both for evaluating claims you might have and for managing the risk of receiving a claim. So first, the focus is really on likelihood of consumer confusion. It's not just a legal test, it's basically this entire analytical framework that trademark litigation is organized around. There's a multi-factor analysis that examines, for example, similarity of marks, relatedness of goods and services in the marketplace, strength of the plaintiff's mark, sophistication of relevant consumers, evidence of actual confusion, that can be a tricky one, and intent of the alleged infringer. From a practical standpoint, that means that trademark clearance, which is the process of evaluating whether a new mark creates confusion risk, should be a routine part of every product naming and brand development process and not an afterthought. you really do want to see what other folks have named their products before you go with a name for your product to make sure you're not going to get hit with a claim later. The cost of identifying a conflict before you launch, it's a fraction of the cost of a trademark dispute after the fact. And if you do pre-litigation decide to change your brand name, that's not a good look right after you've launched a product and not a situation you want to be in. The second dynamic is priority. If you're going to bring a trademark claim, make sure you're the senior user. We've received trademark infringement claims against us where opposing counsel or someone there had not checked the Wayback Machine, which is basically an archive of websites. I highly recommend using it if you're not familiar with it. We checked it ourselves, and as soon as we got a letter, and it was readily apparent that we were actually the senior user. Once we pointed that out to opposing counsel, they tried to drop the claim and got a lot less responsive to us. But we started to then become on offense then. So we started pushing them. We got a coexistence agreement that was very favorable for us. It really reduced the competitors' freedom to operate in the space. And it was all due to their not having really diligence who had the senior mark or checking our website against the web archive before they sent us a demand letter. That was probably a bit of an awkward dynamic for opposing counsel to have with their client, and the client ended up in a much worse space than they started. Again, all because they didn't check priority first. Third dynamic, injunctive relief, which is, well, I'm getting a little bit ahead of myself here, but injunctive relief, we'll talk about that. So that's often the primary remedy that's sought in trademark litigation, and it can be more accessible in this context than other IP disputes. When a competitor launches a product or service under a confusingly similar name, every day that the confusion persists, that's a day that brand equity is getting eroded and that customer relationships are at risk. So getting an injunction early, which is before confusion becomes entrenched in the market, can potentially be more valuable than any kind of damages award. So courts in trademark cases are generally more receptive to the argument that ongoing brand confusion causes irreparable harm. And that's the threshold for showing preliminary injunctive relief. And that's a little bit easier than you get in the patent context, at least today. So brand positioning is the last item here. So how you litigate a trademark case, or even how you threaten to bring a claim and how you frame the narrative, that can have direct implications for your own brand and how it's perceived in the market. And I think the best way to really think about this is, let's say maybe you're a very large company, you have all the right protections in place for your brand, but let's say it's kind of a descriptive trademark, not quite generic, but certainly descriptive. It's probably not a good idea to send cease and desist letters to mom and pop shops who are using similar naming because it is very descriptive. We have not done that ourselves, but I've seen that in the news before. It's not really a good look. It can often backfire. And that really requires, I think, some close coordination between the legal team and business team to say, sure, maybe there's a claim that they're infringing this somewhat descriptive mark, but is this really a good idea to go after someone who just had a Kickstarter with a popular brand themselves using a fairly descriptive name that we're trying to protect? It probably isn't. And again, that's just coordination between business and legal.
Absolutely. So let's, we only have a few minutes left. So let's talk about copyright strategy. And I think there's a misconception that copyright is about writing and artists, but it also relates to engineers, product teams, and companies operating digital platforms. So if your business creates software, produces digital content, or operates a platform that involves media, it's copyright's not peripheral. It's often the central copyright IP protection. And so copyrights arise automatically. And the second it is fixed and created in a tangible medium is the official terminology. So the moment the source code is committed to repository, the moment an article is published, the moment a video is recorded, a copyright protection attaches. You don't have to have an application or registration, it exists. But if you don't register, you forfeit some of the most powerful remedies available, which is statutory damages and attorney's fees. So you want to register your critical copyright as soon as possible so that you can have those protections if you need it. For copyright litigation, so first of all, it has to be copied and it has to be substantially similar. So you have to show that the defendant had access to your work and that the work is substantially similar. And what that means is context dependent, and it's often highly contested. You have to separate out what's protectable, the expression, from unprotectable ideas, methods, and facts. And that can be very complicated in the software context. And often we need experts to do that. And finally, it often overlaps with licensing disputes. A very significant proportion of copyright disputes, it's not about strangers copying. It's about someone who had a license, who's using the content in ways that exceed what the license permitted. So you have to keep an eye on what your licensees are doing. And you have to make sure that you're drafting really careful licenses. So I want to get just briefly at the end about hybrid approaches because so many of our cases have more than one IP, right? And the most resilient IP positions layer multiple rights across different dimensions of the same business. So think about how you can combine patents and trade secret and trademarks or patent and copyright. And this layered kind of protection can really increase your company's position. However, there's always trade-offs, and these three that we've put up here are the most important. Disclosure versus secrecy. Again, we've talked about that, but you need to think about that before you decide which IP protection you're going to have. And then obviously the cost and the speed. And just finally, what we'd like to leave you with, go ahead, Robert, if you want to take this.
I'll just say, I know we are basically out of time, so I think we'll probably just leave you with this slide. But I think the most important thing to take away from this is that I would just say legal and business really should be closely aligned and talking to each other so you're proactive and not reactive. We'll just compress several minutes into it at 10 seconds.
And again, from an outside counsel perspective, if the first time you're talking to your outside counsel is when a problem has arises and things have been misappropriated or infringed, you're not in your best position. So partner up with outside counsel early who can help advise you before litigation happens and hopefully maybe even head off litigation. So we really appreciate your time here. If you have questions, feel free to email either of us. It's been great getting a chance to talk to you about this.
Thank you, everyone.